SJC-12375, Commonwealth v. Joshua A. Richardson.
Ms. Callahan, good morning.
Good morning, Your Honor. Good morning, Your Honors. May it please the Court, Allison Callahan on behalf of the defendant appellant, Joshua Richardson. The Commonwealth stipulated at trial that Mr. Richardson had a valid hardship cultivation license in this matter, and yet at every stage of the investigation and litigation in the case, it was treated as a run-of-the-mill marijuana case, and the import of his right to medical treatment was ignored. In light of the purpose of the medical marijuana law, its changes to the statutory and regulatory landscape relevant to establishing probable cause to search and sufficiency of the evidence of marijuana crimes, this court must reverse Mr. Richardson's convictions and enter verdicts of guilty.
If you're correct, is it necessary to reverse all of the convictions, or would it just apply to the cultivation charge?
It would apply to both charges, Your Honor.
Why would it affect the intent, the possession with intent?
Because there was not intent to distribute demonstrated by the evidence presented.
Okay.
Does that kill, if you lose on that point, if they can show that the intent was to cultivate for sale and to, this were a sham, his permit. His girlfriend testifies that he doesn't smoke very often. She doesn't know why he has the marijuana. He's got lots of baggies down there. He's got a big operation. Can the jury find, even if they can't find the amount, can they find that this is just not believable, that it's for himself, that it's really to sell? Can they do that? Even if the Commonwealth has done a poor job of showing how much marijuana these plants are going to grow?
Until, on the facts of this case,
Well, just generally, can a jury make a determination that this is really a sale, not a possession type of case? He's not doing this for the reasons that he got that license, that it's all a scam.
the Commonwealth could.
And that would apply to both charges? Both the cultivation charge and the intent to distribute?
Not on the facts of this case.
I understand that part I understand. I'm just trying to understand the elements here, and because it gets extremely confusing.
I agree.
Right, okay.
I agree. And I apologize if I haven't
No, you did
presented it in as
You guys
clear a
have
manner
briefed
as
this
I
really well,
attempted
but
to.
it's hard.
I think part of the difficulty, as with any case where you have the analysis of these statutes shortly after the enactment of new legislation, is determining what the interplay is here with the medical marijuana crimes that the defendant has been charged with. So we've certainly done our best to try to analyze it within the framework of this medical marijuana law that creates this right to treatment for patients with debilitating medical conditions.
I'm sorry. Oh, thank you. Can you ask me, and as you recognize, we try to go to the familiar when we're trying to look at new law. How is this not simply a battle of the experts where, and you may disagree with the Commonwealth's expert opinion and say it's not as good as the opinions you had, but isn't this something just a factual finding where we have one person saying these are robust female plants that can yield something and another expert saying that's who they couldn't even tell from the photographs?
In another case, that might have been true. On the facts of this case, that is not true. The jury was asked whether they could find beyond a reasonable doubt if the yield of the plants was certain to exceed 10 ounces. There was no testimony by any expert at trial that these plants were certain to exceed anything. Everything that the jury heard was that the plants could yield, an ounce a plant, could yield nothing, could yield quite a bit more.
Does the ambiguity in the answers, the Commonwealth experts' testimony that we should look at? The uncertainty in the Commonwealth expert.
I believe they testified to a range, and I apologize, I don't have the page cite for Your Honor, but I believe both of these experts testified to a range. So the jury was not presented with any certainty on which to make a finding of beyond a reasonable doubt.
If I can go back to the intent to sell issues, or the possession with intent to distribute.
Yes.
The girl, I know that as part of the motion to dismiss and as part of, I think, the motion to suppress, there was the statement by the girlfriend that I don't know that he smokes either at all or much. Did she testify at trial?
She did testify at trial.
And did she testify that way?
About the, I believe she did.
So
that she didn't see him.
if a jury says he lives with her, I believe, I think she was the mother of his child, wouldn't she know
Well,
if he was smoking medical marijuana for a purpose? And if she did not know, and if there appeared to be materials for sale, and if there did not appear to be the kind of things that somebody would possess if they were to be using it, why would the jury not be able to say, wholly apart from the issue of the 10 ounces, I think that whatever he was cultivating was being cultivated for sale?
I would first start by putting this in the framework of with Your Honor's permission, just the framework of when he got his license. He gets his license in, I believe, July. This happens in September. So we've got plants that are of an age where they had not yet gotten to a point of yielding usable marijuana. 2 points. The medical marijuana law recognizes that there are different ways to use marijuana, and that just because you don't smoke doesn't mean that you're not ingesting it as a medicine. There are tinctures, there are candies, there are oils, there are different ways of ingesting marijuana. So the mere fact that she didn't see him smoke, it doesn't mean that he isn't using it for or has not medicated with it before.
Yeah, but
And the
no
other
bong,
problem-
no bongs, no paper, no pipes.
bongs, no papers.
No bongs, no papers, no pipes, she doesn't see him ingesting marijuana brownies or marijuana cookies. He's got tons of baggies right next to that thing, right? How many baggies does he have?
We don't know.
Yeah.
We're not told. But the bigger problem, Your Honor, is that there's no usable marijuana there.
Yeah,
So
but
what is he supposed to be using?
Say we have a bunch of we have scales too, right? So
Which-
we have people convicted of intent to distribute
Mm-hmm.
without much, without large quantities of drugs on them if the other accoutrements are there. We also have a robbery, sort of a suspicious break-in,
Right.
which is indicia of drug activity, right?
And part of the problem with this is that we're now being asked to read all these things through a lens of someone who is a medical marijuana patient. So if I'm told as a medical marijuana patient by the terms of my license that I'm permitted to use, as here, 10 ounces of dried marijuana bud, I have to have a way of determining how much marijuana bud my plants eventually yield. There's no yield here, but when they eventually do yield, I'm going to be darn ready to figure out how much that is because I don't want to break the law.
Right. I agree with that part.
Also have to measure to return what was ever over the 10 ounces?
Exactly, Your Honor, so that you can return it to a registered marijuana dispensary in accordance with the terms of the CMR.
I get that part, and I also read the testimony. It's all over the place. Basically, your expert says he's a really poor marijuana grower,
Right.
and he's not going to produce
Right.
much. And their expert actually has never seen the marijuana. It's not anyone who arrested them, right? It's someone who looks at the picture and decides whether the plants are female or male.
Right.
And he basically decides that no good grower would have all.
Right, he's decided in his mind that because you have to have this type of plants to yield usable marijuana, that there's no way he could have male plants. And there's no basis for it.
I get that part, but Why can't you convict him on the that the cultivation is also for sale?
Right.
We've got the reflecting tent, and we've got all these other things. We've also got $2,000 on him. We've got the baggies. We've got the break-in. Isn't that a jury question? And also, the judge seems to have instructed in a way that allows, right? The judge's instructions seem to allow that, right, on both charges.
I would again reiterate on the facts of this case, you don't have, the theory of the elite, so let me back up a little bit. Under the CMR, you can grow a number of plants sufficient to maintain a 60-day supply. You can't be penalized for doing that, unless you're doing it for an unlawful purpose. So you have to prove that you're growing too much for an unlawful purpose, or that you have less, and it has an unlawful purpose. You don't know, if your theory is you're growing too much, based on the facts of this case, if you look at all the expert testimony, you don't know that he's growing too much until you have that yield.
Right. I agree
So
with you.
until that moment, I
just can't, I agree with you on that, but it just seems like a jury still can make a conventional analysis that, okay, this guy doesn't seem like he's doing this. There's no smoking, there are no accoutrements of smoking. He's growing, there's also no baked goods or, you make a good point. He gets this certificate in July, but we don't have any other evidence that he's buying other marijuana for other purposes.
Right, and that's really the problem of this case is it seems like a case where the police have essentially just jumped the gun. You just have no way
The Commonwealth
of,
has to wait to see what the yield is?
on the facts of this case, I would argue that you do. If your theory is you're growing too many plants, and we have somebody who's just,
But if the Commonwealth comes around and the person has an acre full of marijuana plants, they don't have to wait to the yield, right? I mean, this is.
that's not the facts of this
That's
case,
what I'm saying,
and
but
all I can
what-
say is,
What you had said is the Commonwealth has to wait, but I
On the
guess what you're really saying, forgive me, but I think what you're saying is, in a small grow like this, absent a statutory or CMR that talks about the number of plants.
correct,
Then the Commonwealth is on precarious grounds.
correct.
When they talk about yield.
Exactly. If their theory is he's growing too many plants, he's going to have too much, and we've got a Commonwealth expert saying he might get an ounce of plant, he might have nothing because he's a terrible grower. We've got issues of mold and botrytis and all these other variables. Until he has that yield, you cannot say that he's violated the law.
But you also have your experts saying, if I had this many plants, I'd have 22 ounces, and we'd be rolling. And
that's part of the problem is there's an assumption, because we're coming into a prosecution kind of with a pre-medical marijuana mentality, we're assuming just because you've got this, you must be an expert grower. There's no evidence that he had any expertise in growing marijuana.
But aren't we
Somebody can-
measuring his intent? Is it intent for himself, or is it intent for sale? And isn't that part of what we're trying to determine here? The jury is trying to decide, is he legitimate, or is he
Right.
trying to sell drugs, right?
Right.
And they can make that call on both counts, right?
They can. I would, just turning back to one of the points that I didn't address earlier with Your Honor, you brought up the fact of this crime, of this alleged home invasion that occurred
Right.
after my client, prior to my client's 911 call. The CMR recognizes that there is a potential for a safety issue and requires that marijuana that's being grown be locked. So we've got recognition.
Be locked, is that what you said?
That it be in a locked area.
Right.
So we've got a recognition by the Department of Public Health, by the legislature, that this is risky business. for somebody who's taking
Right,
this on for
but how
themselves.
do people know that he's got this unless he's selling it too, right? I mean, you've got 4 strangers in his house. Does he say they're in the basement too?
There were 2 gentlemen who entered the basement. My client ran up to the 2nd floor, saw a 3rd person coming up, and then he left. I think that, based on the facts presented, we don't know how they got that information.
Right.
If somebody tells their buddy, hey, I've been really sick, I got this license, I'm really happy, and the word gets out, how does that suddenly make this criminal conduct?
If I could go back to the Justice Gaziano point. So if you're planting an acre, you could be guilty of cultivation.
I suppose you could be.
So what then does, so it is possible, you're not saying that no one could ever be found guilty of cultivation, some can. And what would be the jury instruction that you would give to distinguish those who can be found guilty from those who cannot?
On those facts,
Are you focusing on whether or not
it's hard for me to say that
that the
because
intent at the time of planting or cloning, that you intend at that time of planting or cloning to cultivate a plant that a reasonable person would know would yield more than 10 ounces? Is that the?
so it would be turning back to the language of the CMR, that they're growing more than a number of plants sufficient to maintain a 60-day supply of marijuana.
So you're saying it's the knowledge at the time of planting or cloning?
Based on the language of the, not the CMR, of the Session Laws of 2012, 369, Section 11, that's the language that they use. So I think you have to rely on that statutory language in crafting the jury instruction.
All right.
Again, where you have the facts of this case, where it is such a close case, and where you also have, and I would just turn the court's attention to our argument with regard to per se violation, the fact that you have this requirement that RMDs take excess, that a person is entitled to grow the full amount of what they are prescribed. On the facts of this case, they don't have it.
All right. Thank you.
Thank you.
Ms. May, good morning.
Good morning. Elizabeth May, Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. The defendant relies on Canning to argue that the search warrant was improper in this case because the officers did not confirm how much marijuana the defendant was lawfully entitled to possess. However, the search warrant was proper, and this case presents a very different scenario than the one that was presented in Canning. Now, the difference between our case, the case at hand in Canning, is that in Canning, the only information the officers had in preparing to get the actual search warrant was that the defendant had a marijuana grow. The officers had no information or facts regarding the purpose of the marijuana before applying for the search warrant. Here, in contrast, the affidavit contained facts by a qualified affiant that the marijuana was being grown for distribution purposes. So we have a marijuana grow.
Well, you also had in the affidavit that you did indicate that he had the permit in the affidavit, right?
He did have a
In
license.
Canning, that was the big problem, right? That there was no indication of whether or not he had a permit to do it.
That's correct. Canning did not address whether the defendant had a license. Our argument that here is that the license acts as a red herring. There was no need to confirm whether the defendant was licensed because the officers had probable cause to believe that the marijuana was being grown for non-medical purposes. Therefore, growing any amount for distribution would have taken the defendant out of his license. So then again, we have a marijuana grow, which is all that Canning had, but this case is different because we have the grow plus an abundant indicia of distribution. The facts that in the search warrant for distribution was the defendant's girlfriend's statement that the defendant didn't smoke marijuana on a regular basis, and she didn't know why he was growing the marijuana plants at all. We had facts of drug paraphernalia that were inside the defendant's home. We had a scale and multiple boxes of baggies. There was also facts showing that the defendant was growing psilocybin mushrooms inside the home, and there was $2,135 found in cash on the defendant's person. So again, I would argue that the license in this case is acting as a red herring, along with the expected yield.
Okay, but how about, so what role does it have that we really don't know what the expected yield is going to be? Because that part of the case is pretty weak. You know, I read both experts. Your expert's never even seen the plants. He's looking at a picture. As far as I can tell, it seems silly to think that he can determine the sex of the plants from the pictures. It's all a hypothetical question anyway to him. So does it matter at all? If we don't think you've proven that it's over 10 ounces, or that even in a Lattimore standard, do you still win on both counts, and why?
Yes, Your Honor. There are two ways, the judge instructed on two ways that, two theories of cultivation that the defendant would be in violation of his license, that the defendant grew too much according to the terms of his license, or that the defendant diverted any marijuana for distribution. Here, there was plenty of evidence showing that the defendant possessed the marijuana with intent to distribute. Because of that, the Commonwealth wouldn't have to prove what the expected yield would be in this case, because the defendant violated the law whether or not he had a license to grow at all.
I understand that on the possession with intent to distribute. How about how does the cultivation analysis work? And what are the elements of the crime on cultivation?
Cultivation, I would argue that we'd have to prove that the substance is marijuana in this case. That was stipulated too. That we'd have to prove that the defendant knew he was growing marijuana, not that the defendant knew he was growing too much marijuana. And third, that the defendant intended to grow the marijuana that he had planted. Those would be for the elements for cultivation. Here, we're not addressing
And he knew he was growing marijuana, and what's the third element?
that he intended to actually grow the marijuana that was planted.
Well,
So-
that can't be enough, right? He has to.
We have to exceed the
Yes, so we had evidence in this case of possession with intent to distribute, which would have taken the analysis of expected yield out of the picture.
You're saying that if you're found guilty of possession with intent, you're automatically guilty of cultivation?
Yes, because there are two things that you cannot do according to the terms of his license. You could not distribute the plants or distribute any portion of the plant, and you could not grow too much of the marijuana. Here, the defendant was found guilty of possession with intent to distribute, so at a minimum, we do have that he was possessing the marijuana with intent to distribute it. It takes him out of the terms of his license.
Can we go to the vagueness issue for a moment on this statute? My understanding is that there's a certain amount that can be grown for over a certain period of time. So 10 ounces usable marijuana, 10 ounces of usable marijuana every 60 days. Is that correct?
More precisely, it's that the defendant is allowed to have enough plants to grow 10 ounces of marijuana every 60 days for his personal medical use.
Okay, so some of these plants were tall and some were not. Is
That's
that
correct.
correct? So would those plants have ripened at different times?
Yes, there is.
So would the part that when would the earliest have been? What's the difference in time frame between the small plants and the large plants?
The Commonwealth had introduced testimony through our expert who said that the plants would take about 45 days to flower or to produce usable marijuana, which would be the buds in this case. There was also the expert identified a bud that was on the plant according to Commonwealth's exhibit, which was a picture of the 22 plants in the defendant's basement. After the plants begin to flower, there's testimony from the Commonwealth's expert that it takes approximately 30 days or so after that for usable marijuana to form.
So do we know the difference in age between the tall plants and the small plants?
The Commonwealth's expert testified at trial that the larger plants were approximately 1 to 2 months old, and that's found on volume 5, page 56 to 57. And that all the plants here were female.
But what about the small plants? How old were they?
The Commonwealth's expert did not present testimony as to how old the smaller plants
So should
were.
we just be looking at the tall plants for the 60-day framework?
we should be looking at all of the plants and how much all of those plants could produce in the 60 days. Given that the smaller plants could produce marijuana at 45 days, that's not really the case.
But we don't know that, do we?
No, we just know that the larger plants, for certain, or at least from the Commonwealth expert, that they were 1 to 2 months old. There was a bud on them, and they were at a stage where they could be producing marijuana.
And this license, he got the license in July 2013, and when was this arrest?
His arrest was in September 9th. I'm not sure of the exact date, but I know it's in September.
So let me understand how you understand the statute to work, okay? So let's imagine you've got somebody who has a medical condition, gets a medical license, says, I'm just learning how to do this. I'm going to buy some equipment, but I figure I'm not going to be very good. How many plants do I grow to make sure that I have 10 ounces, which I'm allowed to do? So I decide I need, 20, figuring that I'll lose some of them, or some of them I'll screw up. So I do that, and then it turns out that I'm better than I thought, and that it looks as if the yield may be more than 10 ounces. And I say, okay, well, if it's more than 10 ounces, then I can go and bring whatever is more than that to the registered dispenser, and that's okay. But you say, no, you're now guilty of cultivation because it was more than 10 ounces. How can it be both ways?
I recognize that the Massachusetts marijuana law the purpose of it is to not prosecute individuals for using or growing marijuana for medical purposes. However, cultivators and growers are expected to know how much you are growing and how much it could produce.
But counsel, what I don't understand about that is that the Department of Health doesn't know that either. I mean, it's not in the regulation that you can have, and I think other states do, that you could have a certain number of plants. So if they don't know, how could the new patient know?
I would say that it's not the number of plants that is...
Right, I know it's not the number of plants.
It's the expected yield that would
Right.
be produced from these
But
plants.
that's my point, is that the Department of Public Health doesn't even know how many plants would yield 10 usable ounces.
Well, individuals who have a hardship cultivation license have to follow the industry best practices here.
But those aren't identified, are they?
It's mentioned twice in the regulations.
The word.
The term, yes, industry best practices, involving when a person has a hardship cultivation license, they have to follow industry best practices.
But
and
are
also,
industry best practices defined in the regulation?
it's not defined in the regulations. It is mentioned again on 725.105B1F.
Are there any other statutes, criminal statutes, that you can think of that depend on regulations to fill out the meaning of the crime? Or the elements of the crime, or the when you've reached that stage of...
No, Your Honor.
So this is the only one that kind of refers to regulations, or?
I
guess it's a defense, but there's no other thing you can think of that is like
Not
this.
off the top of my head. I would need to do a little more research to find you a better answer than that.
Ms. May, let me ask you a hypothetical having nothing to do with this case.
Okay.
Let's say that the plants are less than 60 days. Supply is less than 60 days. It's clearly less than 10 ounces. And the police think that they've got information that the defendant's selling marijuana. So they do 3 controlled buys, and the person sells marijuana. Then they send a police officer up, buy marijuana. Mm-hmm. The defendant can be prosecuted for cultivating, even if it's less than 60 days and less than 10 ounces.
Absolutely.
And that's, now you take those and apply it to this case. You're saying it doesn't matter how much it is. It doesn't matter if it's not ready to be harvested. If, in fact, his intent was to sell it, and I'm not saying that you had enough, then there's a cultivation charge.
Yes, if there is evidence that the defendant, like in this case, had marijuana and was found guilty of possession with intent to distribute, that takes the defendant out of his license.
Right.
The license says explicitly that you can't give away the marijuana that you grow, you can't distribute the marijuana that you grow, and you can't grow too much marijuana. Those are the explicit terms of the Chapter 369.
My
That-
point is, I'm not saying you have it here.
Right.
My point is, if you do, of course it can be prosecuted for less than that amount.
Yes.
And where did the judge, in his jury instructions, which I've read, say that?
Yes, the judge instructed the jury on 2 theories of cultivation of marijuana that be in violation of his license. He said that the defendant could be found guilty if he grew too much marijuana according to his license and if he diverted any for distribution. The exact page number, Your Honor.
Because on page 116, there's a reference, but I couldn't tell whether he was referring to both.
Yes, it's on
Whether he
page
was-
116, Your Honor.
Yeah, but you're saying that that's reference to the cultivation and not reference to the intent to sell?
That is in reference to the cultivation charge, that it could be found either of 2 ways, which is in agreement with the actual, with Chapter 369, which is you cannot distribute or give away your marijuana. That would be take the defendant out of the terms of his license. Also, growing too much would, again, take the defendant out of this license.
I don't think he spoke about violating your license during the instructions, did he?
He did mention, he did instruct the jury that the defendant had a license, that was stipulated to by both parties.
Right.
And he had, that he was allowed to grow enough plants allowed to have enough plants to grow 10 ounces every 60 days for personal medical use. That was what was stipulated to here. So he did have a license.
Right.
He is taken out of the terms of his license once the Commonwealth has proved beyond a reasonable doubt that he possessed the marijuana with intent to distribute it. The license, therefore, does not come into play at that point.
I thought they stipulated that he had a license.
He did stipulate, he did.
So if they stipulated he had a license.
He had a
that He had
license.
a license, but now you're saying the license was actually invalid
No,
because he had breached its terms.
yes, Your Honor, I am saying that. I'm saying that he did have a license. It was stipulated to. His defense at trial was that I was growing marijuana according to the terms of my license. Once it was proved beyond a reasonable doubt that he was possessing that marijuana with intent to distribute, his defense is no longer valid. He's taken out of the terms of his license.
If the key sentence in the judge's instructions is this, right? It is the Commonwealth's burden to prove beyond a reasonable doubt that Mr. Richardson had so many marijuana plants that the plant yield was certain to exceed 10 ounces of usable marijuana every 60 days, or that he intended to sell or distribute any of his usable marijuana, right?
Correct.
But when I'm looking at this instruction on page 117, it says, proven beyond a reasonable doubt, he had so many marijuana plants that the plant yield was certain to exceed 10 ounces every 30 days, and not or. So I'm confused as to which instruction we should be following.
I believe the instruction that should be followed is that either that the defendant grew too much according to the terms of his license, or he diverted any for distribution.
So why is that paragraph there on page 117?
Excuse me, Aaron, one second. I believe that the judge is differentiating between whether there was the charge of cultivation and the charge of possession with intent to distribute. He can be found guilty of cultivation if he simply by possessing marijuana with intent to distribute, because it goes against the terms of his license. So again, the judge's original.
But he says and, he doesn't say or.
I don't know if he misspoke, but I believe the instruction that was provided on the previous page is the correct instruction, that he grew too much according to his license, or he diverted any for distribution purposes, which would be any for non-medical use.
If I can go back to the earlier, let's assume everyone's acting in good faith and the person turns out to have a better yield than he expects. He's required to bring the extra yield to a registered provider, correct?
Is he required?
Require.
Under the regulations, an individual is not required to give their excess marijuana to a dispensary. It's the dispensary who is required to accept excess marijuana from an individual.
So I can keep it?
That would, if you have more than 10 ounces, that would go against your license if that's what you were licensed to do.
So what do I do if it turns out that I'm a better farmer than I thought I was?
Bob Crockett.
Well, I would say that the regulations, and specifically 725.035B, requires thoughtful consideration about how to grow. Before you can get a license, you're required to provide the Department of Public Health kind of a list of how you would grow the marijuana and how you would follow the regulations themselves. That would go to you following how much you have to grow, how many plants it would take for you to grow that amount of marijuana. It requires a thoughtful consideration. It's almost a stipulation of knowledge that you're not going to grow that many plants.
I'm allowed to grow 10 ounces.
If under,
What if I grow 11 ounces? I'm supposed to be able to know, this is going to be 10. What if I grow 11 ounces? I'm guilty?
technically, yes. I would say that this is a different case at hand. In the case at hand, we have evidence of possession with intent to distribute. The fact that the defendant had a license to grow any marijuana, whether he's growing 1 plant or 10 plants, is not an issue in this case because he possessed it with intent to distribute. It takes him out of the terms of his license.
I understand that, but of course you've argued that he's also guilty because of the 10-ounce limitation.
I argue that he...
Are you waiving that? Are you saying we should agree with your sister that cannot be the basis for this conviction?
No, it can't. Being able or growing more than in excess of the 10 ounces, although we don't have a plant limit, the expected yield of a plant can vary per plant, per
Right.
strain of plant, per whether it's sativa, whether it's indica.
Whether any dust or bugs blow through the room too, right?
I'm sorry?
And whether any dust or bugs
There are
come through
various
the
factors,
ventilation.
but that is a trial issue. That would be an issue for the jury. They would have Commonwealth present their expert to determine whether that amount would exceed the expected yield. Defense would also bring their own expert. That's a trial issue where we would have to bring in an expert to determine the expected yield of the plants that were found.
And so what if it turns out that I've got 12 ounces or 11 ounces? Am I guilty?
Yes, you would have, if it exceeded your license, which is to grow a number of plants that would produce more than 10 ounces every 60 days, then yes, you would be found guilty. It'd be again, the judge in this case instructed for both. It was growing
Right,
too
no,
much
I
according.
understand, but I mean, you're also resting on the other theory, so,
I'm arguing that the theory that the expected yield in this case is not an issue because he was taken out of his license. Therefore, it's by being found guilty of possession with intent to distribute, he's already taken out of the terms of his license here. He could be found guilty of cultivation because there's 2 elements to having a license to cultivate, which is not exceeding the 10 ounces or however much you're permitted to grow, and that you wouldn't be using it for distribution purposes or giving it away. Those are the 2 elements of cultivation.
So is there a possibility then that the jury could have, is this a jury trial? I can't remember.
Yes, it was.
So is it a possibility the jury convicted him on well, I guess no, because they've convicted him on the intent to distribute. So I'm worried about the fact that the jury could have convicted him on the cultivation count by exceeding 10 ounces, even though that testimony is very weak. Go ahead.
We do not know whether the jury was unanimous as to whether he grew too much according to his license or whether it was because of intent to distribute. But regardless, this is a different situation because we have possession with intent to distribute. That, again, takes him out of the terms of his license. So whether the expected yield in that case, it just doesn't matter.
okay, thank you.
Thank you, Your Honors.
Court, all rise.